will be commencing very, very shortly, in fact now. And just to let you know that we will continue with the evidence from yesterday. There are parts of the arms deal that we didn't quite get to from yesterday's program, and so we will first be continuing with that this morning before we proceed to the state capture part of the tribunal. I would like to call on Mr. Paul Holden, who gave his evidence yesterday, and subsequent to his session, we will move on to the final session of the arms deal with Ms. Patsetsana Molebatsi, as well as Murray Hunter from Right to Know. But for now, Mr. Holden.
Thank you, Mr. Holden. Members, I should just record that yesterday I indicated that I had no further questions for Mr. Holden. Seeing as the members have not yet asked questions, and seeing as I do in fact have one further question, I wonder whether I might be permitted to put that to Mr. Holden.
Even if we had asked questions, you would have had the right to do so. Please go ahead.
Thank you, Member Yaqub. Mr. Holden, in your evidence yesterday about Chippy Sheikh, you mentioned a document called the Devoir and Plimpton Report. It seems to be of incredible importance. Do you mind explaining where it comes from and what it says about the arms deal?
Certainly. And thank you for the opportunity to speak to what I think is a very important document. Before I do so, the reason I think this document is so important is because it speaks to just the overwhelming totality of evidence that we have of wrongdoing in the arms deal. Just to remind the panel, in mine and Andrew Feinstein's joint submission, we point to 2.2 billion rand worth of payments we think are illicit, and undue benefits of over 3.4 billion rand. Some of the details of those payments are included in what we call the Debevoise and Plimpton report. To remind the panel, the report was a report contracted for by Ferristal. Ferristal was a member of the German submarine consortium. The point of the Debevoise and Plimpton report was to have the law firm Debevoise and Plimpton assess Ferristal's legal liability in terms of corruption. They did that by accessing all the internal documents that were available to them, that were given to them by Ferristal, and interviewing a wide range of their staff. And their findings were included in the broader Debevoise and Plimpton report. I should mention that you will be given a printed copy of the section I'm referring to. I would also point out that the section on South Africa was...
Mr. Holden, can you give me the name of that report again? I missed it. I couldn't hear you.
Apologies.
Yeah.
It is the Debevoise and Plimpton report. That's DEBEVOISE ampersand PLIMPTON. Returning to the point I was making, the Debevoise and Plimpton report included information about South Africa, a long discussion, but it was only one of multiple countries in which the company was found to have been making questionable payments to consultants. In total, Debevoise and Plimpton identified over €1 billion of payments that the company had made around the world in places like Liberia. In places like Libya, for example, that the company had investigated.
Sorry, if you could kindly ensure that your cell phones are not too close to the speakers as well, because they really cause interference. So if you're sitting close to a speaker or a microphone, kindly just ensure that your cell phones are away. Thank you.
But the disturbance only seems to happen when you speak.
I don't know whether to take that as a compliment or an insult. My ego says it's a compliment, so I can leave it at that. Returning to the report, the section on South Africa was very revealing. The report indicated that they had discovered 2 primary consulting agreements that the company had entered into. One was with a company by the name of Malar Inc., which I've dealt with previously. That was a company owned by Tony Georgiades. In total, the company was paid 16.5 million euros by Ferrostal between 2000 and 2003. I point out that he was actually hired by Ferrostal in 1998. So that was during the life of the arms deal. If I can, I'd like to read from the Deborah van Plimpton report, which describes this contract. To quote, like Georgiades, through his companies, Mela Inc. and Alandis Greece SA, Georgiades was paid 16.5 million euros by Ferrostal between 2000 and 2004. Georgiades was introduced to Ferrostal by ThyssenKrupp, with whom Ferrostal had worked on the first phase of the South African naval project, which was later separated into submarine and frigate components. In 1997, Christoph Hoornings, and if I may remind the panel, Christoph Hoornings was the executive from ThyssenKrupp who was also responsible for agreeing to the bribe agreement with Chippy Sheikh. Christoph Hoornings of ThyssenKrupp told the Ferrostal employee, then responsible for the submarines project, that Ferrostal should pay Georgiades 20 million rand, and I quote, for the purpose of securing the German package, end quote, and that Georgiades would use the payment to convince, quotes again, key decision makers, end quotes, to support the German bid. Continuing, it says, this is the opinion of Deborah van Plimpton based on their research. It is apparent that Georgiades' chief role was a conduit to politicians. The record shows that he knew a number of senior politicians and introduced Ferrostal employees to these politicians. Indeed, the former head of Marine Force International, one of a subsidiary company of Ferrostal, informed the former CFO in 2003 that, in quotes, political contacts, end quotes, with Malar and previously ThyssenKrupp had a decisive influence on the tender for the submarines. Turning to the second contract, which I feel that information is pretty damning. Turning to the second contract, at roughly the same time as Ferrostal was contracting with Mr. Georgiades' companies, they were also contracting with the companies beneficially owned by a man by the name of Tony Ellingford. Tony Ellingford was extremely close to Defense Minister Joe Modise. When Joe Modise passed away, it turned out that Tony Ellingford was one of the executors on his estate. I'd like to highlight something in here, which I'll read, is that Ellingford was introduced to Ferrostal by Lou Swan. You may remember that I mentioned Lou Swan yesterday. He was the chief of Arms Corps, and he's also been accused of receiving payments from Ferrostal, which I'll deal with here. So to quote once again, Tony Ellingford was a former executive in the defense industry hired by Ferrostal in 1998 to advise on the submarines contract. Like Georgiades, he was paid 16.5 million euros by Ferrostal between 2000 and 2003 through his company Kelco Associates SA. According to consultant Jeremy Mathers, another one of Ferrostal's consultants, Ellingford was hired because the responsible Ferrostal board member in the late 1990s wanted someone with, quotes, political connections, end quotes, to help Ferrostal win the contract. Mathers asked Llewellyn Swan, an old contact from the South African defense industry, for advice. Swan recommended Ellingford, who was then hired by Ferrostal. Ellingford, like Georgiades, also had multiple political connections and introduced Ferrostal to various decision makers, including Defense Minister Joe Modise. I find it interesting that he actually introduced Ferrostal to Joe Modise. Returning to the quote, there is evidence of meetings arranged and intelligence gathered by Ellingford, but the amount of work done does not seem commensurate with the payments he received. It appears he, like Georgiades, was paid to provide political access. The involvement of Swan was likely another instance of payment for access to decision makers. Swan was CEO of Arms Corps Limited, the South African arms procurement parastatal, from late 1998 until late 1999. In that position, he was one of the key individuals deciding who would win the submarine contract. In November 1999, weeks before the submarine contract was awarded, Swan unexpectedly resigned from Arms Corps. No later than March 2000, he was working for Ferrostal, albeit indirectly. At that time, Ellingford informed Ferrostal that Calco was working with a subcontractor called Moist CC, represented by Swan. I think that shows very clearly that there was damning evidence, the Deborah Van Plimpton report. And if I may, I know I'm taking up some time this morning, I'll point out the Deborah Van Plimpton report also dealt in detail with Mr. Chippy Sheikh. In their investigations, they established that Mr. Chippy Sheikh had entered into a business arrangement with Ferrostal subsequent to his employment as Chief of Acquisitions. Ferrostal was the largest contributor to a mining project in Mozambique, which is run by a company called Enable Mining. I pause to note that other directors of Enable Mining, according to the company's register, was one Juleka Mohammed, who was the acting attorney for Jacob Zuma in the early phases of his corruption proceedings. I think altogether that paints a very clear picture of what was happening in the arms deal, and I think gives a flavor of just the incredible clarity and the overwhelming nature of corruption in the arms deal. Thank you.
Thank you, Mr. Holden. Panel members, those are all of my questions.
Okay, thank you.
Thank you very much, Paul. In your the written submission to the tribunal, you describe what you call a quandary about dealing with the arms deal when we've had the Seriti Commission, and your attitude to the Seriti Commission is very clear in the submission. I just wanted to know how would you like this panel to deal with numerous issues that you've raised in relation to the arms deal, in the light that there's been a Seriti Commission, and also that the commission itself is being taken up for a court review?
I think it's a difficult question, and obviously something that the panel members will ultimately decide. And I'd also be very interested in some of the legal expertise contained on the panel about this matter. As far as I can see, the panel this is a inquisitorial process. It's intended to discover the facts. It doesn't make legal findings necessarily. I would argue that the panel should use its judgment to compare the totality of the facts that I present in my joint submission with the findings of the Seriti Commission and decide which one is more credible. In so doing, I think that you should give consideration to the very voluminous papers that were submitted by Corruption Watch and R2K. I think the facts established therein, and I think they are incontrovertible because they are based on the record of the Commission's own proceedings, point to very severe problems with the way in which it conducted itself. I don't think on the evidence in that submission, I know it will be dealt with in a lot more detail later, that the Commission was of a mind to pursue evidence, and when it was presented evidence that indicated corruption, was of a mind to ignore it. I would like to point out one example just off the top of my head, because there were just so many to choose from in the Seriti Commission report, is that Jacob Zuma's name appears a total of 2 times in the entire report. He's not mentioned once in the finding of fact, neither is Shabir Sheikh. I think that says everything you need to know. Shabir Sheikh was found guilty of corruption related to this arms deal. Jacob Zuma was indicted for corruption in this arms deal. During proceedings, Mr. Seriti indicated that he thought that Jacob Zuma's trial was of no relevance to the arms deal because I assume he was talking about the bribe payment of 500,000 Rand, that it concerned matters happening after the arms deal. I point out that the submission in the Corruption Watch and R2K case shows that in the indictment of Jacob Zuma, there is a heading called the arms deal. It is dealt with throughout the should be a Sheikh submission, should be a Sheikh conviction. So on the balance of facts, I don't think it's necessary for the commission to make, for the panels to make a finding on the commission and the case against it currently, but I do think the panel is empowered to have a look at the facts and see which facts are more credible.
Okay, just to follow up, in your written submission again, you do say that there's some primary information that's useful, and you referred to a Colonel Johan deploys. Would you share why, after all the dismissive attitude on the Seriti Commission, you think that Colonel Johan deploys thing is
Well, I think he's of relevance. I think he's interesting for two reasons. The first is that Colonel Johan deployed, to give some background to him, sort of on his behalf, is that he was a senior investigator with the MPA and with the Scorpions, and he investigated numerous aspects of the arms deal up until the closure of the investigation of the arms deal investigation in 2011. In that role, he was privy to a huge amount of information and had access to primary material stemming from those investigations. Colonel Johan Deploy made a submission to a witness statement to the Commission, and appended to that witness statement were, I can't remember the exact number of pages, but it was a very voluminous number of pages of primary evidence emerging from those investigations. Those are documents that we can confirm were seized by the Scorpions in their investigations or presented to them, and I don't think there's any reason to doubt their authenticity. What the Seriti Commission did with those documents, I submit, was unacceptable, and I don't necessarily agree with every element of Johan Deploy's testimony necessarily. But I do think that the primary material he attached to his submission is fascinating and very enlightening. In the same way, in a concluded corruption trial, you might access the record of that corruption trial, and in so doing establish that there's a wide range of primary material on which you can rely. And that's how I feel that we should treat that particular set of evidence.
okay.
Mr. Holden, following on the question put to you with regard to the Seriti Commission, would it be true to say that this People's Tribunal has been presented with new and emerging information and documentation because of ongoing investigations conducted by you and Henny van Buren and Corruption Watch and so on?
Yes, I think there has been some new information that's come to light. Where it has come to light, I have indicated it in the submission that I've made. It's a bit of a strange thing to try and explain. The new information that has come to light came to light, weirdly enough, through the Seriti Commission, I would argue. There was a huge amount of primary material that we had been denied access to. I'd remind the panel that I was actually called as a witness, and I withdrew in protest of the way the Commission was conducting itself. And I was entitled to documents which I was never provided. I spent a good deal of time looking through that primary material, which was posted online, and found within it enormous amounts of new information, in particular attached to Colonel Johan Deploy.
So actually it's old information newly discovered.
I think so. I think it's old information. Some of it's old information that has never been presented in public, certainly. It's never been published. It's never been discussed in the media. It's certainly never been presented in evidence here, and a lot of that evidence was not addressed during the Seriti Commission of Inquiry.
And would one of them be the Federal Commission report that you spoke about this morning?
If I may, the Department of Implementation report came to light before the Commission started conducting its work. As a bit of background, at the time, there was during the Greek Euro debt crisis, and there was a lot of anger around the way in which Greece was being forced to, during a period of enormous financial constraint, cut social spending, but at the same time honor commitments flowing from defense contracts, in particular with ThyssenKrupp and Ferristal. And there was a lot of anger that there was alleged corruption in that case. And as a result, somebody felt compelled to leak that document, the full document, online. In terms of the Sariti Commission, I attached that, well, myself and Andrew Feinstein attached that to our joint submission. We tried on a number of occasions to admit the Ferrostar report to the Commission. During proceedings, the chair ruled that it was inadmissible on privilege grounds, which I would argue he was mistakenly, which he did mistakenly according to the law, which I'm sure will hopefully be dealt with in later submissions. But what is very interesting is that in that final report, he said, even though we didn't admit it during proceedings, we were given it confidentially, and we would like to deal with it in Volume 1. This is dealt with in Volume 1. And amazingly, and I think this speaks to the attitude of the Commission, it said, even if this document was admitted into evidence, it wouldn't materially change our findings. With regards to the information I gave you on Chippy Sheikh, and I think I'll try to quote as best I can, the Commission said that nothing turns on the information that Chippy Sheikh was employed by an arms deal contractor subsequent to the contract. So, in fact, a lot of the information has been in the public domain for a long time. I've written 2 books on the transaction. I think what's useful about a process like this is to bring out documents that in the maelstrom of corruption allegations in South Africa get lost and deserve repeating.
So I just need a small clarification. Where do we find this evidence of Chippy Sheikh receiving 3 million or 2 million? Yesterday you said that Suklal had alluded to that, but he didn't before us, did he?
Correct me if I'm wrong. He mentioned it very briefly in passing, that he was told that Chippy Sheikh had received a $1 million bribe from Thales and a $3 million bribe on the submarine contract, if that's correct. If I may ask my evidence leaders a question, there will be a transcript of these proceedings or a summary. Okay. The video is available, so if we need to clarify that, we can. But to my memory, I think he did raise it.
All right, thank you. Thank you very much.
Okay, I have no questions of you, but just to say 2 things. Your report has been very fascinating. Thank you for all the hard work. I have been persuaded with your argument as a reasonable one. If we talk about, we could have a 5-hour discussion on a minor debate I have here and there, which is quite pointless for this exercise, because generally speaking, I agree. So I thought I should just give you 1 word of advice and leave it at that. The advice is, when you don't know whether something is an insult or a compliment, just take it as a compliment.
Thank you very much.
Thank you very much.
I will take your compliment again.